Hi, I'm Dave Dinkel, and we're getting started on seminar number 2 of my real estate rescue plan. Because contracting is so critical, and it's a fact that stops many new investors from getting started, I'm going to cover the purchase and sale and other types of real estate contracts. So as I've said before, I'm devoting this series to people who are serious about changing the course of their lives and taking action to fulfill their personal dreams and financial destiny. As that may sound corny to some of the listeners, it's the reality of what you need to do if you're going to be focused on making real estate investing work for you. The more you persist, the harder you work at it, the more rewarding it is. If you take it to be something you want to try to see how it works, what you're going to wind up doing is watching a lot of YouTube videos. And there's nothing wrong with YouTube videos. Some of them have great content, but ultimately you're not going to get started. So to this end, I'm focusing this seminar series on those critical obstacles that all of my students had faced before or after they got started. As I found from doing this series, as I started to get into it more and more, I realized that each of the steps in getting from getting a signed contract to actually closing are the major fears at different times and stages of an investor's life that he faced. The only way to overcome them is to do them, fail forward, and learn from your failures. Now, this series is not designed to be a mentoring or coaching program. I'm not going to look at individual properties for listeners or someone who is sending me questions, very simply because it's not fair to my other students. If any viewer is motivated to get started sooner and to go further, then we have programs available for you to change your career and get your life on a path to greatness. In terms of affordability for our programs, they are the least expensive, the true mentoring programs in the United States that I know of. The caveat to that is they include doing closed deals with us as your partners, and we do supply the funding for your same-day double closing transaction. I designed this series with all the information you need to get started as a real estate investor, but it by no means is the level of sophistication of our mentoring and coaching programs. What most investors tell me is there's just so much information they don't know where to start. And that's true. But it's the old proverbial story. How does a pygmy eat an elephant? One bite at a time. What we're going to try to do in this series is take those bites one at a time in a sequential series so you're covering yourself as you take each step forward. It wouldn't be fair to our students who pay us for personal hands-on training to give people that enter these seminars the same feedback or coaching that our students get. I'm sure you can understand that. Making a lot of money and being very successful takes courage, persistence, and learning as you fail forward into greatness. If you look at two students, we have two success levels. They absolutely go on to enormous success after their second or third or fourth transaction. Or they fail from the start. They never really get started because of things they either don't want to do or they're afraid to do, both of which can be overcome by simply looking at that 800-pound gorilla in the room and tackling that sucker. Predominantly, it comes down to picking up the phone and calling and failing forward. Ironically, what most investors think is that realtors know much more than they do about investing. They do not. They know much more about the legalities of how they became realtors, but not about investing. Only a few who graduate to a level of hybridism figure out the synergy between using their professional license along with their savvy as being a real estate investor to getting larger profits plus commissions on every transaction they do. Over the years, I've probably said this what seems like a million times. Why not you? So why not you? Your inability to get started in real estate investing is not because of all the excuses that I hear. I don't have the money, I don't this, afraid of that, so on and so forth. In the previous seminar, I covered fears and how to overcome them. But why not you? Why can't you use your personal brilliance in whatever that is to get into real estate investing or some other profession that you love to go to your work, if you call it work? That's your choice. Or as unprofound as it is for me to say it, you're where you are because of choices you've made. Good, bad, or ugly, we all make choices, and we wind up having to live by the choices we've made. So step one, deciding on what purchase and sale contract to use. The adage that a contract can be written on a napkin is absolutely true. So can wills and many other contracts. The issue is not what it's written on. The issue is enforceability when all the parties in the contract don't abide by its terms and conditions, or there's not terms and conditions where there should be some for unforeseen circumstances. Two people can look at the same clause in a contract and totally interpret it differently. If you take that same clause and go into a room of 3 attorneys, you can get 5 to 7 different opinions about what it is and how it is. Are any of them wrong? I don't know. I don't know which one's right. One of the things I would suggest, and I see it happen, I don't like it, but I see it happen a lot. Investor gets into a situation, he's got a roadblock. So he wants some advice. So what does he do? He calls another investor and another investor. Typically, he stops at the last investor who tells him what he wants to hear, and he moves forward. Unfortunately, that may not be the right answer at all. When somebody comes to me and says, what would Dave Dinkel do in a situation like this? And I tell them what I would do. I have no expectation they're going to go out and do that. My expectation is the last person to talk to them is most likely what they're going to actually do. Do not allow yourself to get into that situation. Go to the source of the person who has the most experience in the market, the most experience in doing deals, and rely on their experience rather than what you want to hear as an answer. As a matter of fact, I got a call today, and it was regarding a short sale. Many times in short sales, the homeowner hasn't made a payment for years. He saved up his payment. He saved cash. What does he want to do? Well, maybe he paid $300,000 for the property. The short sale is going to be approved at $120,000. He wants to buy his house back at $120,000. But most often, the short sale approval letter has a stipulation that says, this is an arm's length transaction, and the buyer cannot be involved in any way, shape, or form selling it back to the seller of the property. So there you go. What does that mean? Is it bank fraud if you violate the terms of that? Well, it's certainly serious, and depends on if the bank finds out and they want to take action against you. Now, when this investor called me and said, what would you do? I wouldn't break the law. There may not be a jail for people that do that in this situation, but you certainly could have a deed rescission, or you could be fined or sued. Don't get into it. Don't set yourself up. This person that's the homeowner of the property has made a choice to not make his mortgage payments, save money, outwit the bank, and good for him. He now has to survive the circumstances of those choices. Now, most new investors use a simple 1 or 2 page contract they've gotten online from a guru. And it's easy to get them online. It's very simple to get them from gurus. And typically, if they're 1 or 2 page contracts, they lack a lot of the true grit that a contract should have for what-if situations. Now, if you're running into a homeowner and you get them to sign a 1 page simple contract and you're saying to them, look, these other investors who are going to come by have these 10 page, 11 page contracts. Mine's very simple. You're right. It is very simple. The problem is it may not contain the clauses that you need to keep you out of trouble later or to keep the seller from simply canceling the contract. Keep in mind that if you're going to use one of these simple contracts, it will work until you have a problem. Then you could lose the deal, lose your earnest money deposit, and if it's a B2C leg, in other words, you're now the seller, you could easily be sued by the end buyer if he knows what he's doing. There's no question that these work, and literally probably tens of thousands are used weekly in actual transaction. When they don't work is when the problems set in. Again, what you stand to lose is an earnest money deposit, even if it's a small one, the deal, and you could be sued by your end buyer if you've already signed him up. On that note, if I don't mention it elsewhere, I'll mention it now. I do transactional funding in 39 states. And in Georgia, one of the things that I see a high propensity of is the investors actually are licensed. They are brokers. They have their own brokerage firm. Whether or not they actually have agents doesn't matter. If they do have agents, they are typically what are known in the industry as bird dogs. In other words, the broker will get a data collection service and generate leads, give it to these people who are bird dogs, and send them out, and the broker says, here's 5 leads. When you bring those back with a written response of what happened to our contracts, I'll give you another 5. And that's what they do. And they can have a horde, literally, of people wanting to get into the real estate industry who really wanted to be investors, actually having leads to go out and do it, and putting properties under contract. Now, here's the reason I mention it. When I see their A to B and B to C contracts, and remember, I'll cover it for the people who haven't heard this before, the A letter designation is for the original seller, the owner of the property on title. If an investor comes in and buys it and is reselling it, he becomes the seller. but he's not on title until he actually closes. So the B of the A to B leg is the investor. When the investor goes to sell it, it becomes a B to C transaction. B is the investor, C is the end buyer in the transaction. It's called an A to B and B to C closing. Now there are times when I've seen A to B, B to C, C to D, D to E, and E to F transactions, and they're just as good as the weakest link of all of those people in there. If one of them fails because his buyer doesn't come to closing, everyone loses everything down the chain. If you're in one of those transactions where you have more than an A to B and B to C, make sure you get the earnest money deposit before you sign the contract with your end buyer. My point is this: in these contracts that the brokers or agents in Georgia use, the A to B contract is a very simple one-page or two-page contract maximum. And the idea being that, so as not to confuse the seller, here's what we use. However, when they go to resell the property to whether it's an investor, a rehabber, or an end buyer, they use the state contract. In Georgia, it happens to be what's called a GAR, which is the Georgia Association of Realtors and the Bar Association already approved contract. Now the issue becomes when there's a contract dispute and you have a risk of loss of the deal. Should be the bigger loss in the transaction, or your earnest money deposit or good faith deposit, your EMD or GFD. So by having this simple contract anybody can read and look at in 30 seconds or less, what you haven't covered is what happens in case of default. I'm going to talk about assignment of contracts later. We're going to mention it right now. If you're going to do an assignment of contract, okay, fine, not a problem. But you better make sure that your earnest money deposit is covered in that contract. So when you assign that contract and you assign it for a $10,000 fee, make sure that your end buyer gives you back an additional, whatever your earnest money deposit was, $100,000, $500,000, whatever it happens to have been. Otherwise, you're only entitled to the $10,000 because that's what your assignment fee says. I'm going to mention this now because it's on my mind, because it just came up and it was a major issue with two of my students. They put a property under contract, advertised it, found an end buyer, and they decided to assign the contract. They wrote their own assignment of contract, as they always have, and it said basically that they were bringing a buyer to closing to purchase the property at a specific price. I'll say $250,000. What happened is the end buyer came to closing and he said, I don't have any more money. You're going to have to take $248,000 or nothing at all. So of course, the B investor who got the contract said to the investor who he assigned it to, what are you going to do? And that investor said, I'm going to take the $248,000. How about splitting the difference with me? And my student said, no, we're not going to split it. We're entitled to our fee and we're going to take our fee. So what happened is the investor who got the assignment from my students went ahead and closed. And what happened? The assignment fee that they expected to receive wasn't paid to them. Now if you're saying what happened? Well, very specifically, their contract assignment stated that the buyer they brought was going to pay $250,000 as an example. He didn't pay $250,000. So the contract was breached, and that means it was unenforceable in the eyes of the seller, the original end buyer, the other investor who got the assignment, but not in my student's eyes. Their attitude was, hey, we brought him, and of course the investor says, well, you brought him, but he didn't pay the full amount. So as it ultimately turned out, they didn't get their money. It was sent back to the investor, who then went ahead and closed with their end buyer directly. So is that wrong? Not exactly, because the contract was black and white. They should have had a clause, a sentence that said, if in fact for any reason the price is reduced or end buyer closes for a lower amount, a difference of the amount is reduced from the profit of the investor buyer, or we split the difference. So the point I'm making here, I'm belaboring it because a lot of people do assignment of contracts. You better read through them carefully and add verbiage that protects you in the event of different parties on either side disagree. So most investors tell me they're afraid of the consequences of being sued and understanding the legalities of the contract. And that's a very valid fear if you let it be a fear. Typically, you're not going to get sued unless you don't perform up to the conditions of the contract. Anything is possible. Anyone can sue anyone for any reason or no reason at all. Going through life, that's something you find out the first time you get sued and you didn't do anything wrong. There are any number of very powerful corporate executives who use the power of lawsuits to, I'm going to say, kill opponents in whatever they're working on. I've seen many, many cases where a person absolutely in the wrong sues the person in the right, knowing they're in the wrong, but also knowing they have more money to carry the lawsuit. While I understand your situation, if you do things right and protect yourself with clauses that the opposing party signs in the contract, you have to do your best. That's all you can do. Out of thousands and thousands and thousands of closings, I've only been sued a couple of times. And I was in the right, but it didn't matter. I still got sued. So if you're sitting there and saying, I don't want to take a chance on being sued, you've got your head in the sand. Get over it, move forward. Let me ask you this question. Do you think that a guy that runs a $1 billion or $5 billion or $2 billion corporation doesn't get sued? The likelihood is he has lawsuits coming into his company every day. Oh yeah, he has attorneys to take care of it, and so do you. You find an attorney who will work with you. Go to the local RIA's vendor list and look for attorneys that are investor friendly, and if they don't do the legal work, somebody they can refer you to. The only winner in any lawsuit is the attorneys, not the buyer, not the seller, so on and so forth. I've seen some horrendous amounts of potential lawsuit judgments become smoke simply because what the investor did is he had the shield of a limited liability corporation, and what he did is he just closed it down. So when people say to me, should I have my own LLC, sub S corp, corporation, limited partnership, and should I have that before I get started? My answer is you don't need to. Just get started in your own name, because your limit of liability 99.99% of the time is going to be your earnest money deposit as a buyer. If you do your contracting properly, you should never have a problem. If after 1,000 or 2,000 contract you get hit with a lawsuit for some reason, deal with it. You're not going to get hit with lawsuits right off the bat. Stop making excuses for not getting started. Frankly, you should be concerned, but overcoming this fear is very simple. Now again, I said this before, I strongly suggest you read any contract you'll be using. And when you don't understand anything, if possible, ask the source of where the contract came from. For realtors, this is very simple. In their contract, they have a legal hotline, and they can call pretty much at any time and ask those guys, I guess they're paralegals or attorneys, what if I do this? That person on the other phone is always going to take the most conservative side. And oftentimes, if you don't give him all of the information and very specific details, you could get the wrong answer. Now, if you have a guru contract that you picked up offline and you can find out who the guru is, call him and ask him, email him. The issue is it's hard to go to a YouTube video and say to the guy, hey, I don't understand this. And I'm not making a case specifically for mentoring or coaching, but it can be critical to your future success, and whatever that mentoring cost is can pay for itself in one single transaction. Okay, the sources of real estate contracts are, first and foremost, the State Realtors Association. This is the pinnacle of legal contracts, but anything in it can be changed or modified very easily to fit an investor's needs. What's the contract for? It's specifically designed to protect the seller and to a much bigger benefit to the listing agent and the listing agent's broker, so he has control over what the listing agent is using as a legal contract. Again, anything in there that you don't want to have, you can change or modify. Whatever is written in print in the contract can be overridden by a simple addendum signed by all the parties to the addendum. Is the realtor a party to the contract? No. He's a party to his listing contract, not to the purchase and sale contract. So you don't need the listing agent's approval to add an addendum. The problem is he acts as a roadblock to get to the original seller of the property. So even though this is a great contract, in many states you have to be a licensed agent to use it. In some states you can actually lease the contract without being licensed. In other states they have two contracts, a bar association contract and a board of realtors contract, both of which may be published online for people to use. So whatever state you're in, you need to do a little research to find out if you can use the board of realtors actual contract. What if you very simply go to a licensed agent and say to him or her, will you write these contracts for me? The immediate response you should get is absolutely. Why does he say that? He says that, or she says that, because she believes that she can go in and get the listing agent to split his commission. Is that going to be the case? Typically, no. And here's the reason. And a lot of people will dispute what I'm saying, but we see it happen nearly every day. Listing agent has a contract, 6% commission. Property is listed listed for $100,000. I come along with a buyer's agent in tow. Buyer's agent submits my contract for $110,000. Immediately, the listing agent is not going to get $6,000 in commission. He's going to get half of $6,600. 6% times 110,000, 6,600 divided by 2 is $3,300. He's lost $2,700 in commissions by allowing you to bring me to the table. So if you're in any kind of market where it's warm or moderately warm or hot, he's going to say to you, it's not a substantial enough offer. This happened to me. I went before the board of realtors to do a talk on what was supposed to be short sales, and I asked this question: have you ever actually gone in as a buyer's agent and had your offer turned down, and then you checked later in the public record to see what it sold for, and it actually sold for less than your offer? And out of the 300 and some people were there, at least half of them stood up and started screaming like I turned on a riot. So the question is not, does it happen? It's, how often is it going to happen to you? If you make an agreement with a listing agent and you say to him or her, write the contracts for me, they should ask you, how am I going to get paid if I don't get half the commission? What you're going to have to do is pay them somehow, or they're not going to do it for you. The other option, of course, is to become a licensed agent, and you can write your own contracts. I'll talk about that later because it's becoming an issue in certain states. Okay, there are exceptions I mentioned for non-licensed individuals to use the contracts, but the best way again is to simply Google real estate contract or contracts for a specific state. And what you'll see is a lot of different types of contracts coming up, including national contract vendors. And these are companies that have attorneys that in those states they specifically devise legal contracts. They sell them online. Now some states have many different contracts for the different counties that they have in the state. So you have one basic contract, but each county has a different addendum or contract, and they go back to colonial times, literally, in terms of why they have the different contracts and what the regulations are in each of the counties. You just have to deal with those, that's all. Don't worry about it. Fail forward, you will learn. But you have to do something. On these contracts, they're sold also in big box stores. Now, what kind of contracts are they? Well, typically, their quitclaim deeds are general contracts that you can fill in the blanks. Besides being in the stationery stores, you can Google real estate contract for whatever state you're in and just go through them. Many of them will have the first page of the contract or the entire contract, and that opens an opportunity for you to do it yourself. I don't know that's a good option for most people. You know, a lot of people come to me and they are practicing law without a license. They really think they know the regulations and the laws because they spend a lot of time doing it. But now we're talking about seriousness because you're signing a contract that you have to stand behind. The cost of these contracts varies from as little as $15 that I've seen them to over $40. Depends on the state, depends on the complexity of the state's real estate laws. So now we have guru contracts. These are usually 1 or 2 page purchase and sale contracts written by a national or local real estate investor, guru, and may or may not be attorney approved. In most cases, they're not attorney approved. And they oftentimes, because they're very simple, so when you sit down in front of a property owner, seller, the investor is designed, his speech or his script is designed to say, we make this very simple. Let me go over exactly what the contract says. And he goes through, number 1 says, you're the seller, I'm the buyer. It also says this is a legal and binding contract. If that investor is smart, what he puts at the top of the page is not contract or purchase and sale. He puts standard agreement for the sale of real estate in blank state. Is that a standard contract? Of course it is standard for that investor, but it gives some credibility to the seller who's sitting there looking at your page. Now, here's what can happen. First of all, you never do one of those sit-down presentations with one spouse and not both of them there. Otherwise, you've wasted your time. But what can happen here is, very simply, the seller can say, okay, do you mind if I show it to my attorney? And your answer is going to be, well, gee whiz, by email. No. And that's the typical answer because you don't want an attorney to see this very short and onerous contract that you're presenting to the seller. I want to give you a very good example. I went out to see a seller of a property lakefront, talked to him. What he hadn't told us, I'm going to say his name was Sam Johnson. Sam Johnson was on title, except this wasn't Sam Johnson. Sam Johnson was his father who had passed away 18 years before. And Sam Johnson Jr. just kept living in the house. But I said to Sam, here's the contract, here's what I can do. What are your feelings about it? And he said, do you mind if I read it overnight? He didn't say, I want to show it to my attorney. He said, can I read it overnight? I was not a licensed agent, but I leased the contract from the board of realtors. And I said to him, absolutely. You take it and read it over, and I'll answer any questions you have. And if you want to show it to your attorney, show it to him. But it's already been approved by the Bar Association. See, it says here, FAR Bar. That means the Florida Association of Realtors and the Bar Association. Again, I was leasing the contract. So he called me up the next day and he said, I want you to come by the property again. So I went by the property again and he said, I'm going with you. It's the lowest offer that I had, but in reality I trust you because you're the only one of 7 or 8 investors who came by to see me that it would allow me to keep the contract overnight to read it. Now, how long does it take to read a 1 or 2 page contract? Not very long. But the mere fact that these other investors wouldn't allow him to look at it overnight just simply shut him down. So what these guru contracts can sometimes miss are the clauses that can be most effective in keeping an investor out of legal issues. What sort of legal issues? I can go into a whole bunch of them, but remember, you have to bring the seller to closing. This is a legal and binding contract. It may not say in your contract that if there is difference of opinion that it goes to arbitration. It may not say that it goes to court. What does that mean? What you've set yourself up for is being sued, because if the original seller breaches the contract, his only recourse is very simply to go to an attorney and say, this guy's bugging me, I don't want to sell my house. And then you're going to get a strong letter from the attorney, and then you're probably going to get sued. Don't set yourself up for failure. So here's number 4, it's do-it-yourself contracts. These are the ones that investors put together themselves, practicing law without a license, from any or all of the above sources. And it can look pretty good, frankly. I mean, you can get clauses here and clauses there. What you want to have is the mindset of why all these clauses are flowing together and bringing the property to an end at a closing table. I once leased a storefront, put in a stock brokerage firm that I wanted to lease a physical location. I went to a shopping center that was being put in. I asked to see the lease. They sent me a 30-page lease, and almost every other paragraph was copied and pasted, not really very well. Literally, it wasn't put on a computer and copied and pasted. It was cut from other contracts, pasted onto a piece of page, and then copied. And it was the shabbiest looking thing I'd ever seen. But it was a 30-page contract. The one thing that was most important was I would not do a personal guarantee. I started to say one of the most respected gurus in the industry, and I should have said one of the longest lived gurus in the industry, signed personally on commercial loans. He told me he lost $100 million because of it. I think he's told the public that he lost $50 million. Whichever way it was, if you have to do a deal where you sign personally, you better make sure you have some other out of that contract or you don't do it. While these things can cover most of the day-to-day issues that you'll encounter, they can be seriously lacking when it comes to a legal challenge. And sometimes people will go for years using these do-it-yourself contracts and there's no problem. I remember seeing a YouTube video one time where the guy said, see this check? This $65,000 or $68,000 I just had to pay to an attorney because when I went to closing, I didn't want to pay for title insurance. I've told all my students, don't worry about it, don't pay for title insurance. Just let the end buyer coming in pay for title insurance. And I didn't pay for title insurance. And of course what happened is there was a challenge to the title. I didn't have insurance. I had to pay it out of pocket. And then in sort of a smug answer he said, but I saved so much money on the title insurance and all the other ones, I made up for it. Well, typically the title insurance is 1/2 of 1% or less of the purchase price of the property. So he would have had to do an awful lot of properties to make up for that little issue that turned into a big problem because he purposely overlooked it. So napkin contract, as silly as it sounds, a handwritten napkin can be legal if it fulfills the state requirements for contract content. You know, what are the state requirements for contract content? Well, they can be anything depending on the state. But as a simple example, a contract must have a starting and ending date, or it is likely illegal because contracts do not have forever terms. They're used to buy or sell, and then they are no longer valid. So once you make this decision of which contract to use, you'll then practice modifying it for each of the various types of usage that you'll encounter. So what I'm going to show you now is how we use one single contract, a purchase and sale agreement, for the 5 types of usages that are most common that you'll see. Again, there's only 5 basic types of contracts, especially a new investor would be using. You need a buy contract or a purchase contract. The other thing I kind of glanced over when I was talking about putting at the top, standard agreement for the purchase of real estate. Remember when I said that? I didn't use the word contract. If I did, slap my face. You don't use the word contract when you talk to a seller. You always use the word agreement. Even in your contract, you don't call it that, you call it an agreement. Why? Because it's just more digestible to somebody that's looking to sign it. So in this case, you, the investor, are the buyer of a property. A sales contract. This is where the investor is the seller of the contract. And this doesn't mean you just simply switch you as the buyer to you as the seller and put a new buyer in. That's only the first thing that comes up. You also now, since you're the seller of the property, you have to bring that end buyer to closing, and you have to collect an earnest money deposit and some other things that I'll go into in a moment or so. So we have a purchase or buy contract, a sale contract, now a short sale contract. What's different about this? The seller is the owner of the property, but his lender has to approve the sale price if the mortgage that's due on the closing is more than the sale price. He has to take a haircut or a principal reduction on that mortgage. So here's what happens. You go out to the seller and he says to you, by the way, I have a foreclosure coming up next week. Can you stop the foreclosure? You look at it, he owes $300,000 on a $100,000 property. And you say to him, I can stop it, but we have to do a short sale. And the seller says, give me a contract. I'll sign anything. You give him a contract for $40,000. He signs the contract. You now have a contract that may or may not be, and most likely will not be approved by the lender. So if you go out and market the property, remember you better have a clause to your end buyer that says this property is involved in a short sale, and if the approved price is not approved by the seller, that's you now, the contract is null and void. Otherwise, if you don't have something like that in it, your end buyer can sue you for breach of contract because you didn't deliver the property to him. The most important thing in a short sale contract, which I've used it for many years, and finally the Florida Board of Realtors and the Bar Association put it into their standard contracts, is that the inspection period starts only after you receive lender approval in writing. Most realtors are going to say to you, no. As soon as the contract is signed, that's the effective date and the inspection starts. So let's say you get a whopping 15-day inspection. You go out there, look around, people are living in there, nothing's happening. 3 months later, you get an approval from the lender, you go out there, the house is burned down. They put concrete in toilets, whatever they did, it's not what you saw. Now, normally an agent will say to you, don't worry about it, we'll take care of it, but that's not what the contract says that you signed. So this clause can be added if it's not already in a short sale addendum that you're looking at. REO contract, this means it's an REO property already foreclosed by a lender, and they're now selling the property. Very often times the closing agent has been chosen by this lender because he's an attorney who did the foreclosure procedure but wasn't paid very much for it. And the lender has said to that attorney, when we sell the property, you can do the closing. That's when you can make your money. That's all well and good except for one thing. If you're going to do a same-day double closing, and you don't want to close on the property and carry it until you find a buyer, that closing agent may not allow you to do that. Because remember, he's working for the lender, and the lender typically doesn't want you to make money off of their REO property unless you rehab it, put it through the market again, so on and so forth. You have to ask that question. Is the closing agent willing to do a double closing? How do you do that? Have somebody else call up the closing agent and ask, are you willing to do a double closing on an REO property? If they say no, it's not to you, but you'll now know that you have to have another closing agent for the B2C leg. REO Fannie Mae contract. This is a standard REO contract, and by the way, when I mentioned to you clauses that fit into these different types of contracts, in an REO contract you cannot have any clauses. Nothing fancy like one last inspection, any of that stuff won't be approved. Not only that, the lender sends back an addendum to your contract which overrides anything you have in the contract. It effectively null and voids your contract. In Fannie Mae, I think it's an 11-page contract. The other issue with Fannie Mae is the earnest money deposits are too large to be workable for us. Fannie Mae developed an online auction system called HomePath. So when you put an offer in to a Fannie Mae agent or broker, it goes right into the auction system. And what everybody else gets to see is your offers. All you're doing is competing against yourself to find somebody that won't put in a higher offer than you, which usually means you wind up paying too much. The exceptions are a critically damaged property that has a lot of rehab to bring it back to usage by humans. So all the above contract can actually be the same contract with very different clauses and provisions, or no clauses and no provisions as in the REO contracts. You have to add these or check the appropriate boxes. That's the reason for reading the contract. You need to understand what that contract's about. If an agent sends you a contract and you strike things out and you put something else in there and you initial that, what happens is you send it back and the seller typically will then initial that. Here's the problem. That appears, if you have to go to trial or court or you get in a dispute, that those changes were made on the effective date of the contract. They could have been made a week later because you didn't get the contract back timely. So normally what happens is the listing agent goes back to the seller and says, I got this contract and the buyer made some changes to it. So what we're going to do is we're going to go ahead and initial these. They send it back to you. But what if they don't send it back for 4 or 5 days? Your inspection period's already started. So by the time you get it back, if you see something else you don't like, you have to send it back again. By the time you get it back, you're through the inspection period. Your earnest money deposit is hard. So whenever you get a contract back that has a change on it, you have to initial it to make the change valid. You always date that change so that that's when the new effective date takes place. Or your inspection period starts from that date, not the original effective date. Very, very, very important, because you can make a change that's a minor change to send back to the seller to make his initials. But when you date yours, you've moved up the effective date to the new date. So the critical clauses are concerns that need to be modified in the contract I'm going to show you in a second. By far, these are not everything, and you're going to stumble into some as you read your contract. You may hate reading, and you may hate reading contracts specifically. Generally, the legal profession has said we want to write these changes or clauses or addendums so they can be read by the public, and make sure you understand them. If you don't, strike them out and rewrite it as to the way you want it to be or the way you understand it. Name of the seller and his marital status. This is very important if he's married or divorced, because he cannot sell that property without spousal approval. Even if he's divorced, the divorce decree has to say that he gets the entire proceeds of the sale of the property. Otherwise, he may be selling the house and his spouse may be entitled to the proceeds, or half the proceeds, in which case your contract is only valid for half the property. Now, if you're saying to yourself, Dave, you're going into all these details and things like that, yeah, that's because it can happen to you, and ironically more frequently in this case than you might think. Now, if the seller is an entity, then make sure the managing member or authorized representative or trustee is mentioned as the seller, not just in the final signature. Get his name on the front page of the contracts so the listing agent knows who to contact. Okay, now this is a very common thing that a lot of investors do because they've heard it on a lot of YouTube videos. When you're the buyer, you put yourself or your entity as buyer, and you put on there and or assigns. That was fine 25 years ago, maybe even 20 years ago. But what it does is it immediately alerts the seller or a listing agent that you may not be the buyer, or most likely are not the buyer, and you're wholesaling the property or the contract. Any contract is assignable if it doesn't specifically state that it's not assignable. This is true in every state in the union. It's been through the courts numerous times, and I've had any number of attorneys dispute that with me until they've read the law and found the statute that specifically says that. I'm not going to do it for your state in here. You either have to believe it or don't believe it, or ask enough attorneys to find one that understands the nature of this particular clause in any contract, not just real estate. Legal description. This is important. I suggest you use the verbiage as shown in the public record instead of a specific designation in the public record, where you've actually taken a description and copied and pasted it, and you have an invalid description for any reason. Copying and pasting it may not always work correctly. In older properties, that legal description of the property can be one sentence, or maybe as little as 4 or 5 words. But in a new subdivision, that thing can be a full legal page. What if you put it in incorrectly? You have an invalid contract if the seller wants to enforce it as such. What about the acceptance date? You don't want to send the contract to an end buyer or to a seller and not have them sign it within a certain time period. You want to put a little pressure on them. So this refers to the date the contract has to be signed, not the date it's received by an investor or an original seller. Now this can be critical, and you send out a contract with an acceptance date of 3 days later. And in the interim, you get another buyer who offers more money than your first end buyer who didn't respond timely. What do? Well, you have to go back and say to the original buyer you had that said he wanted the property and let him see the contract, has he signed it and has he sent it back with his earnest money deposit? Because if he hasn't sent it back with his earnest money deposit, depending on what your contract says, it may not be valid. Many standard contracts allow the earnest money deposit to come in within a certain time period. I would suggest you do not sign your seller contract to your end buyer until you get earnest money deposit, because if you sign it beforehand, he doesn't send in his earnest money deposit. He still has a valid contract that has to be canceled by both parties when you go to the closing agent to close the contract. If he then further puts a notice of interest, memorandum of contract, affidavit of contract, or whatever else he calls it in the public record, he can hold you hostage and get a fee from him to cancel that contract. So do it right in the first place. Closing date. This is critically important. If you're buying, typically an agent will tell you it's on or before a certain date that you have to close. If you're writing a contract, you want it to say on or about that date. What's about? Well, for us, it saved us millions of dollars in having to get an extension because it's already there. It doesn't say I have to close on April 15th. It says about April 15th. What's about April 15th? For us, it's lasted as long as a month or so. When you become the seller, that's when you use on or before. Now, sometimes you'll see a contract that says closing on April 15th. What does that mean? Well, theoretically, if you come and close before that, you don't have a contract. You've invalidated, breached the contract because that's not what the contract said. You may have no recourse for the end buyer because that's what the contract said, and your seller said, I can't get to sign the papers until the 16th. This sounds silly, but when it happens to you, it's going to be very, very expensive because you're going to lose the deal or you're going to lose your earnest money deposit. Inspection period. This is the most important clause in your contract, and it allows you to cancel your contract without risking the loss of your earnest money deposit or good faith deposit. The most important thing in this specific instance is to add in your addendum a little clause that says inspection period is in business days. Boom, that's it. This will give you an extra 2 days for every 5 days of inspection you're already getting approved. If you're looking at a commercial property of any type, multifamily, strip center, anything, you don't have to have an inspection period. You can ask for a due diligence period, which is typically anywhere from 30 to 180 days, depending on the size of the property and various things like that. Addendums. These are specific clauses of any nature, typically a contract extension, lead-based paint disclosure, LBPD, if the home was built pre-1978. You want to choose the closing agent or the escrow agent. Always trying to know ahead of time what closing agents are investor friendly. I mentioned it before, but the easiest way is to go to your local RIA's website, look up vendors, and find attorneys or closing agents that advertise there. Now you can put any other type of disclosure that protects both you and the seller. Very oftentimes listing agents will want a full disclosure of deficiencies in the property, I'm going to call them. That's a very, very important document. If there's a deficiency in there, for example, no permits were pulled for the work that was done on the property, you need to fully disclose that to your end buyer in writing. I haven't mentioned any kind of specialty contracts, which are commercial, land contracts, multifamily contracts. What I suggest you do, I haven't mentioned them up till now simply because they're not what the average investor needs to start out using. If you have yourself looking at a piece of land, multifamily property, you should use that specific contract or the clauses in those specific contracts that are pertinent to that type of property. That can be very, very, very important. For example, let's say you're buying a piece of raw land that used to have a building on it. You can see the building foundation there, but you don't really know for sure what it was. But as you look closely, you see it had open large areas, which might have been garage doors. You buy that property and you come to find out that you have bought into a cesspool of old gas tanks that have leaked into the ground. Well, you bought it that way. You didn't know any better. Oftentimes what you hear a seller say was, well, I don't know if it had permits. I bought it that way. It must be grandfathered. There's no grandfathering of these sorts of things. And if you bought a property that in fact is a commercial property that has old battery acid, gasoline, oil, and things like that, you now have assumed the liability of cleaning up that land. So be extraordinarily careful, or make sure you do those things in an LLC that you can walk away from. The most often used contract for beginning investors is what's called an assignment of contract. This is a very simple, typically one-page contract. This allows an investor to assign his equitable interest that he received from the seller when he signed the contract with the original property owner. That equitable interest he is assigning in his purchase contract to an end buyer directly. Again, these assignment of contracts are all over the internet. Most of them are fine, but you have to read them and understand what happens, what if. Earlier I gave you an example where it cost two of my students over $10,000 because they just didn't word it properly. Only left out 3 or 4 words. So the investor is going to receive a fee for this service on the closing statement, which can be called a joint venture fee, an assignment fee, a contractor's fee, anything you want to disguise it as, but the end buyer pays it on the closing statement. And typically what you normally will have, I mentioned this before, is an A to B and then a B to C closing. In this case, the process is A to C. The issue with this method of doing the assignment of contract is that it limits the investor to small profits. The reason being is the seller and the end buyer both know what the investor is making. The seller comes to closing and he's getting $100,000. He sits down, he looks at the contract, and it doesn't say he's selling it for $100. It says he's selling it for $120,000. And his question is, my God, where's the $20,000? Well, you're getting the $20,000. So that can become hard for you to explain what happened there. I hear this all the time. I already told the seller I'm going to make money on it. He said he doesn't care how much. I already told the end buyer he doesn't care how much I'm making. They both love their sale price and purchase price. That's until they got to the closing table. Then they realized that you may be making 5 to 10 times the realtor commission if they had sold it through the MLS. And very often, either one or both of them don't close. So don't set yourself up for failure. Now, several states, including Illinois, Oklahoma is looking at it now, and I don't know how many other states, have outlawed what they call wholesaling. And they're requiring either a double closing or the investor has to get a real estate license and fully disclose that he is, I'm going to call him the outlaw in this transaction for wholesaling the property. Their definition of wholesaling is assigning or selling the contract. That's what they call wholesaling. Double closings are one of the exceptions for those transactions. If you decide you must get a real estate license, then you have the State Board of Realtors contract available for you to use. And as I mentioned before, you can modify that immensely. What I see is hybrid agents use their own personal contracts. These are the 1 or 2 page ones. When they're the buyer, they use that as their contract between themselves and the seller. Then when they go to resell it, they use the state board contract because it protects them more. It doesn't protect the seller, it protects the listing agent and broker. How do I know that? Because I do the transactional funding for the A to B and B to C closings. Yes, realtors can also be investors despite what you may have heard. For the facts on being an investor and being licensed at the same time, which is the reason that most people got licensed. They wanted to be investors, felt they were going to be closer to the real estate market and find deals. When they got licensed, they realized that's not the case. And being an agent is very difficult to make a decent living. Go to my book on hybridism. www.davedinkel.com/hybridism. If you're a student of ours, we provide you with sample purchase and sale contracts for your personal or corporate use. While you can modify a standard contract for any use, if you find yourself looking at a piece of land or a multifamily property, Check out the State Board of Realtors contracts to see what clause or clauses you might need. While contracting may seem to be bewildering at times, it should be one of your strengths because this is where the money comes in at closing. It's also an opportunity to use the black and white of your contract's terms to keep sellers and buyers in line and to make sure you at least get the end buyer's earnest money deposit and that you don't lose your earnest money deposit. Please use the following email address to send in your questions after this seminar: blogdavedinkel@gmail.com. Thanks very much for attending tonight. I wish you limitless success in all that you do.